Electoral tribunals and the Commission on Appointments. Q. Suppose there are 202 members in the House of Representatives. Of this number, 185 belong to the Progressive Party of the Philippines or PPP, while 17 belong to the Citizens Party or CP. How would you answer the following questions regarding the representation of the House in the Commission on Appointments? Question 1. Question A. How many seats would the PPP be entitled to have in the Commission on Appointments? Explain your answer fully. Question B. Suppose 15 of the CP representatives, while maintaining their party affiliation, entered into a political alliance with the PPP in order to form the Rainbow Coalition in the House. What effect, if any, would this have on the right of the CP to have a seat or seats in the Commission on Appointments? Explain your answer. A. The 185 members of the Progressive Party of the Philippines represent 91.58% of the 202 members of the House of Representatives. In accordance with Article 6, Section 18 of the Constitution, it is entitled to have 10 of the 12 seats in the Commission on Appointments. Although the 185 members of Progressive Party of the Philippines represent 10%, 10.98 seats in the Commission on Appointments, under the ruling in Gingona versus Gonzalez 214 SCRA 789 1992, a fractional membership cannot be rounded off to full membership because it will result in overrepresentation of the political party and underrepresentation of the other political parties. Letter B. The political alliance formed by the 15 members of the Citizens Party with the Progressive Party of the Philippines will not result in the diminution of the number of seats in the Commission on Appointments to which the Citizens Party is entitled, as held in Cananan versus Tan 55 SCRA 1 1962. A temporary alliance between the members of one political party and another political party does not authorize a change in the membership of the Commission on Appointments. Otherwise, the Commission on Appointments will have to be reorganized as often as votes shift from one side to another in the House of Representatives. Powers. Q. Why was elected senator in the May 1987 national elections? He was born out of wedlock in 1949 of an American father and a naturalized Filipino mother. Why never elected Philippine citizenship upon reaching the age of majority? Before what body should T, the losing candidate, question the election of Y? State the reasons for your answer. A. T, the losing candidate, should question the election of Y before the Senate Electoral Tribunal because the issue involved is the qualification of Y to be a senator. Section 17, Article 6 of the 1987 Constitution provides that the Senate and the House of Representatives shall each have an electoral tribunal which shall be the sole judge of all contests relating to the election, returns, and qualifications of the respective members. Q. What is the function of the Senate Electoral Tribunal and the House of Representatives Electoral Tribunal 2006 Bar? A. The function of the Senate Electoral Tribunal and the House of Representatives Electoral Tribunal is to be the sole judge of all contests relating to the election, returns, and qualifications of senators and congressmen, respectively. Section 17, Article 6 of the Constitution. Q. What is the composition of each? A. The Senate Electoral Tribunal and the House of Representatives Electoral Tribunal are composed of 9 members, 3 of whom are Justice of the Supreme Court, designated by the Chief Justice, and the remaining 6 members are senators and congressmen, respectively, chosen on the basis of proportional representation from the political parties as well as the parties registered under the party list system represented in the House of Representatives in the case of the latter. Section 17, Article 6 of the Constitution. Q. Beauty was proclaimed as the winning candidate for the position of representative in the House of Representatives 3 days after the election in May She then immediately took her oath of office. However, there was a pending disqualification case against her, which case was eventually decided by the Comelec against her 10 days after the election. Since she has already been proclaimed, she ignored the decision and did not bother appealing it. The Comelec then declared in the first week of June that its decision holding that Beauty was not validly elected had become final. Beauty then went to the Supreme Court questioning the jurisdiction of the Comelec, claiming that since she had already been proclaimed and had taken her oath of office, such election body had no more right to come up with a decision, that the jurisdiction had already been transferred to the House of Representatives Electoral Tribunal. How defensible is the argument of Beauty? 2014 Bar. A. The House of Representatives Electoral Tribunal has acquired exclusive jurisdiction over the case of Beauty since she has already been proclaimed. The proclamation of the winning candidate is the operative fact that triggers the exclusive jurisdiction of the House of Representatives Electoral Tribunal over election contests relating to the election, returns, and qualifications of the winning candidate. The proclamation divests the Commission on Elections of jurisdiction over the question of disqualifications pending before it at the time of the proclamation. Any case pertaining to questions over the qualifications of a winning candidate should be raised before the House of Representatives Electoral Tribunal. Lim Kai-chung versus Comelec 583 SCRA 1. Halosos Jr. versus Comelec 674 SCRA 530. Alternative answer. The argument of Beauty is untenable. For the House of Representatives Electoral Tribunal to acquire jurisdiction over the disqualification case, she must be a member of the House of Representatives. Although she had been proclaimed and had taken her oath of office, she had not yet assumed office. The term of office of the members of the House of Representatives began at noon of the 30th day of June next following their election. Reyes versus Comelec 699 SCRA 522. Powers of Congress, legislative inquiries, and the oversight functions. Q. Congressman Nonoy delivered a privileged speech charging the Intercontinental Universe Bank with the sale of unregistered foreign securities in violation of RA 8799. He then filed, and the House of Representatives unanimously approved, a resolution directing the House Committee on Good Government HCGG to conduct an inquiry on the matter in aid of legislation in order to prevent the recurrence of any similar fraudulent activity. The HCGG immediately scheduled a hearing and invited the responsible officials of Intercontinental Universal Bank or IUB, the chairman and the commissioners of the Securities and Exchange or SEC, and the governor of the Bangko Sentral ng Pilipinas BSP. On the date set for the hearing, only the SEC or SEC commissioner appeared, prompting Congressman Nonoy to move for the issuance of the appropriate subpoena ad testificandum to compel the attendance of the invited resource persons. The IUB officials filed suit to prohibit HCGG from proceeding with the inquiry and to quash the subpoena, raising the following argument. The subject of the legislative investigation is also the subject of criminal and civil actions pending before the courts and the prosecutor's office. Thus, the legislative inquiry would preempt judicial action. Answer. The argument is not tenable. Since this is an essential component of legislative power, it cannot be made subordinate to criminal and civil actions. Otherwise, it would be very easy to subvert any investigation in aid of legislation through convenient ploy of instituting criminal and civil actions. Standard Chartered Bank, Philippine Branch versus Senate Committee in Banks, Financial Institution, and Currencies, 541 SCRA 456. B. Compelling the UIB officials who are also respondents in the criminal and civil cases in court to testify at the inquiry would violate their constitutional right against self-incrimination. Are the foregoing arguments tenable? Reasons. Answer. The argument is untenable. Since the IUB officials were not being subjected to a criminal penalty, they cannot invoke their right against self-incrimination unless a question calling for an incriminating answer is propounded. C. May the governor of the BSP validly invoke executive privilege and thus refuse to attend the legislative inquiry? Why or why not? Answer. No, because the power to invoke executive privilege is limited to the President. Senate versus Ermita 488-1. Q. The House Committee on Appropriations conducted an inquiry in aid of legislation into alleged irregular and anomalous disbursements of the Countrywide Development Fund, or CDF, and Congressional Initiative Allocation, CIA, of Congressman as exposed by X, a division chief of the Department of Budget and Management, DBM. Implicated in the questionable disbursements are high officials of the palace. The House Committee summoned X and the DBM secretary to appear and testify. X refused to appear, while the secretary appeared but refused to testify, invoking executive privilege. A. May X be compelled to appear and testify? If yes, what sanction may be imposed on him? Answer. X may be compelled to appear and testify. Only the President or the Executive Secretary, by the order of the President, can invoke executive privilege. He can be cited for contempt and ordered to be arrested. B. Is the Budget Secretary shielded by executive privilege from responding to the inquiries of the House Committee? Explain briefly. If the answer is no, is there any sanction that may be imposed upon him? 2010 Bar. Answer. The Secretary of Budget and Management is not shielded by executive privilege from responding to the inquiries of the House Committee on Appropriations because the inquiry is in aid of legislation and neither the President nor the Executive Secretary, by the order of the President, invoked executive privilege. For refusing to testify, he may be cited for contempt and ordered to be arrested. Q. Several senior officers of the Armed Forces of the Philippines received invitations from the chairperson of the Senate Committee on National Defense and Security for them to appear as resource persons in scheduled public hearings regarding a wide range of subjects. The invitations state that these public hearings were triggered by the privileged speeches of the senators that there was massive electoral fraud during the last national elections. The invitees Brigadier General Matapang and Lieutenant Colonel Makatuwiran, who were among those tasked to maintain peace and order during the last election, refused to attend because of an executive order banning all public officials, enumerated in paragraph 3 thereof, from appearing before either House of Congress without prior approval of the President to ensure adherence to the rule of executive privilege. Among those included in the enumeration are senior officials of executive departments who, in the judgment of the department heads, are covered by executive privilege. Several individuals and groups challenged the constitutionality of the subject executive order because it frustrates the power of the Congress to conduct inquiries in aid of legislation under Section 21, Article 6 of the 1987 Constitution. Decide the case, 2015 Bar. Answer. Under Section 5, Article 16 of the Constitution, the President is the Commander-in-Chief of the Armed Forces of the Philippines. By virtue of this power, the President can prevent the Brigadier General Matapang and Lieutenant Colonel Makatuwiran from appearing before the Senate to testify before a legislative investigation. The provision in the executive order which authorized department secretaries to invoke executive privilege in case senior officials in their departments are asked to appear in a legislative investigation is unconstitutional. It is upon the President that executive power is vested. Only the President can make use of executive privilege. The same case, Senate versus Ermita, 2006. Limitations on legislative power. Q. In 1963, Congress passed a law creating a government-owned corporation named Manila War Memorial Commission, MWMC, with the primary function of overseeing the construction of a massive memorial in the heart of Manila to commemorate victims of the 1945 Battle of Manila. The MWMC charter provided an initial appropriation of 1 million, empowered the corporation to raise funds in its own name, and set aside a parcel of land in Malate for the memorial site. The charter set the corporate life of MWMC at 50 years, with a proviso that Congress may not abolish MWMC, and requiring that the funds raised by it be remitted to the National Treasury. The MWMC challenged the validity of the law, arguing that under its charter, its mandate is to complete the memorial no matter how long it takes. Decide with reason. A. The contention of WMC is untenable. An implied limitation on legislative power is the prohibition against the passage of irrepealable laws. Such laws deprive succeeding legislators of the authority to craft laws appropriate to the milieu. Limitations on revenue, appropriations, and tariff measures. Suppose the President submits a budget which does not contain provisions for CDF or countrywide development funds, popularly known as the pork barrel, and because of this Congress does not pass the budget. Will that mean paralyzation of government operations in the next fiscal year for lack of an appropriation law? B. Suppose in the same budget there is a special provision in the appropriation for the armed forces authorizing the Chief of Staff, AFP, subject to the approval of the Secretary of National Defense, to use saving in the appropriations provided thereto to cover up whatever financial losses suffered by the AFP retirement and separation benefit system in the last 5 years due to alleged bad business judgment. Would you question the constitutionality validity of the special provision? Answer: no. The failure of Congress to pass the budget will not paralyze the operations of the government. Section 25, number 7, Article 6 of the Constitution provides, if by the end of any fiscal year the Congress shall have failed to pass the General Appropriations Bill for the ensuing fiscal year, the General Appropriations Law for the preceding fiscal year shall be deemed reenacted and shall remain in force and effect until the General Appropriations Bill is passed by the Congress. Answer to letter B. Yes, the provision authorizing the Chief of Staff, with the approval of the Secretary of National Defense, to use savings to cover the losses suffered by the AFP, retirement and separation benefit system, is unconstitutional. Section 25, number 5 of Article 6 of the Constitution provides, no law shall be passed authorizing any transfer of appropriations. However, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of constitutional commissions may, by law, be authorized to augment any item in the General Appropriation Law for their respective offices from savings in other items of their respective appropriations. In Philippine Constitution versus Enriquez, 235-506-544, the Supreme Court held that a provision in the General Appropriation Act authorizing the Chief of Staff to use savings to augment the funds of the AFP retirement and separation benefits system was unconstitutional, while Section 25, number 5 allows as an exception the realignment of savings to augment items in the General Appropriations Law for the executive branch. Such right must and can be exercised only by the President pursuant to a specific law. Q. What are the limitations or restrictions provided by the Constitution on the power of Congress to authorize the President to fix tariff rates, import and export quotas, tonnage and wharfage dues? Explain. Answer. According to Section 28, Number 2, Article 6 of the Constitution, Congress may, by law, authorize the President to fix within specified limits and to such limitations and restrictions it may impose tariff rates, import and export quotas, tonnage and wharfage dues, and other duties or imposts within the framework of the National Development Program of the government. Q. Suppose that the forthcoming General Appropriations Law for year 2002, in the portion pertaining to Department of Education, Culture and Sports, will contain a provision to the effect that the Reserve Officers Training Course ROTC in all colleges and universities is hereby abolished, and in lieu thereof, all male college students shall be required to plant 10 trees every year for 2 years in areas to be designated by the Department of Environment and Natural Resources in coordination with the Department of Education, Culture and Sports, and the local government unit concerned. It further provides that the same provision shall be incorporated in future General Appropriations Acts. There is no specific item of appropriation of funds for the purpose. Comment on the constitutionality of said provision. Answer. The provision is unconstitutional because it is a rider. Section 25, Number 2, Article 6 of the Constitution provides, no provision or enactment shall be embraced in the General Appropriations Bill unless it relates specifically to some particular appropriation therein. The abolition of the ROTC involves a policy matter, as held in Philippine Constitution Association versus Enriquez 235 Square 506. This cannot be incorporated in the General Appropriations Act but must be embodied in a separate law. Presidential veto and congressional override. Q. The President signs into law the Appropriations Act passed by Congress, but she vetoes separate items therein, among which is a provision stating that the President may not increase an item of appropriation by transfer of savings from other items. The House of Representatives chooses not to override this veto. The Senate, however, proceeds to consider two options: 1. To override the veto, and 2. To challenge the constitutionality of the veto before the Supreme Court. Number 1. Is option 1 viable? If so, what is the vote required to override the veto? Number 2. Is option 2 viable? If not, why not? If viable, how should the court decide the case? Option 1 is not viable inasmuch as the House of Representatives, from which the Appropriations Act originated and to which the President must have returned the law, is unwilling to override the presidential veto. There is therefore no basis for the Senate to even consider the possibility of overriding the President's veto. Under the Constitution, the veto of 2/3 of all the members of the House of Representatives and the Senate voting separately will be needed to override the presidential veto. Number 2. It is not feasible to question the constitutionality of the veto before the Supreme Court. In Gonzales versus Macaraig, 191 Square 152, the Supreme Court upheld the constitutionality of a similar veto. Under Article 6, Section 27, Number 2 of the Constitution, a distinct and severable part of the General Appropriations Act may be the subject of a separate veto. Moreover, the vetoed provision does not relate to any particular appropriation and is more an expression of a congressional policy in respect of augmentation from savings than a budgetary provision. It is therefore an inappropriate provision, and it should be treated as an item for purposes of the veto power of the President. The Supreme Court should uphold the validity of the veto in the event the question is brought before it. Q. Ernest Cheng, a businessman, has no knowledge of legislative procedure. Cheng retains you as his legal advisor and asks enlightenment on the following matters. A. When does a bill become a law, even without the signature of the President? Letter B. When does the law take effect? Answer. Under Section 27, Number 1, Article 6 of the Constitution, a bill becomes a law even without the signature of the President if he vetoed it but his veto was overridden by 2/3 vote of all the members of both the Senate Senate and the House of Representatives, and if the President failed to communicate his veto to the House from which the bill originated within 30 days after the date of receipt of the bill by the President. B. As held in Taniata versus Tubera, 146 466, a law must be published as a condition for its effectivity in accordance with Article 2 of the Civil Code. It shall take effect 15 days following the completion of its publication in the official gazette or in a newspaper of general circulation, unless it is otherwise provided. Executive Order Number 292, Revised Administrative Code of 1989. Power of impeachment. Q. What are the grounds for impeachment? Explain. That's from 1999 bar. Answer. Under Section 2, Article 11 of the Constitution, the grounds for impeachment are culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, and betrayal of public trust. Q. Is cronyism a legal ground for the impeachment of the President? Explain. A. Yes. Cronyism is a legal ground for the impeachment of the President. Under Section 2, Article 11 of the Constitution, betrayal of public trust is one of the grounds for impeachment. This refers to violation of the oath of office and includes cronyism, which involves unduly favoring a crony to the prejudice of public interest. Q. As a leading member of the Lapiang Mandirigma in the House of Representatives, you were tasked by the party to initiate the moves to impeach the President because he entered into an executive agreement with the U.S. ambassador for the use of the former Subic naval base by the U.S. Navy for free, example, without need to pay rent nor any kind of fees as a show of goodwill to the U.S. because of the continuing harmonious RP-US relations. Cite at least 2 grounds for impeachment and explain why you choose them. 2013 bar. Answer. The President can be impeached for culpable violation of the Constitution and betrayal of public trust. The Supreme Court has already ruled that the provision in Article 18, Section 25 of the Constitution requires a treaty even for the mere temporary presence of foreign troops in the Philippines. Bayan versus Zamora, GR number 138570, October 10, 2000, or 342-499. The President cannot claim, therefore, that he acted in good faith. Report of the Special Committee in the impeachment of President Quirino, Congressional Record of the House of President Quirino, Congressional Record of the House of Representatives, Volume 4, page 1553. Betrayal of public trust includes violation of oath of the office of the President. In his oath of office, the President swore to preserve and defend the Constitution. Executive Department. Privileges, inhibitions, and disqualifications. Presidential immunity. Upon complaint, Q. Upon complaint of the incumbent President of the Republic, A was charged with libel before the Regional Trial Court. A moved to dismiss the information on the ground that the court had no jurisdiction over the offense charged because the President, being immune from suit, should also be disqualified from filing a case against A in court. Resolved the motion. 2010 bar. Answer. The motion should be denied according to Sullivan versus Macasiar, 167 SCRA 393. The immunity of the President from suit is personal to the President. It may be invoked by the President only and not by any other person. Presidential privilege. Q. Distinguish presidential communications privilege from deliberative process privilege. 2010 bar. Answer. Presidential communications privilege applies to decision-making of the President. The deliberative process privilege applies to decision-making of executive officials. Unlike the deliberative process privilege. The presidential communications privilege applies to documents in their entirety and covers final and post-decisional matters, as well as pre-deliberative ones. The deliberative process privilege includes advisory opinions, recommendations, and deliberations comprising part of a process by which governmental decisions and policies are formulated. Neri versus Senate Committee on Accountability of Public Officers and Investigation. Powers. Executive and administrative powers in general. Q. The President abolished the office of the Presidential Spokesman in Malacanang Palace and a long-standing bureau under the Department of Interior and Local Governments. The employee of both offices assailed the action of the President for being an encroachment of legislative powers and thereby void. Was the contention of the employees correct? Explain. Answer. The contention of the employees is not correct, as held in Buklod ng Kawanihan, IIB versus Zamora 360-718, 2001, Section 31, Book 3 of the Administrative Code of 1987 has delegated to the President continuing authority to reorganize the administrative structure of the office of the President to achieve simplicity, economy, and efficiency. Since this includes the power to abolish offices, the President can abolish the office of the presidential spokesman, provided it is done in good faith. The President can also abolish the Bureau in the Department of Interior and Local Governments, provided it is done in good faith, because the President has been granted continuing authority to reorganize the administrative structure of the national government to effect economy and promote efficiency, and the powers include the abolition of government offices. Presidential Decree Number 1416 as amended by Presidential Decree 1772. Q. To give the much needed help to the province of Aurora, which was devastated by typhoons and torrential rains, the President declared it as a state of calamity. Give at least 4 legal effects of such declaration. Answer. Declaration of a state of calamity produces inter alia these legal effects within the province of Aurora. Number 1. Automatic price control under RA number 7581, the Price Act. Number 2. Authorization for the importation of rice under RA number 8178, the Agricultural Tarification Act. Number 3. Automatic appropriation under RA number 7160 is available for unforeseen expenditures arising from the occurrence of calamities in areas declared to be in a state of calamity. Number 4. Local government units may enact a supplemental budget for supplies and materials or payment of services to prevent danger to or loss of life or property under RA number 7160. Number 5. Entitlement of hazard allowance for public health workers under RA number 7305, Magna Carta for public health workers, who shall be compensated hazard allowance equivalent to at least 25% of the monthly basic salary of health workers receiving salary grade 19 and below, and 5% for health workers with salary grade 20 and below and above. Number 6. Entitlement to hazard allowance for science and technological personnel of the government under RA number 8439 and 7. A crime committed during the state of calamity will be considered aggravated under Article 14, Paragraph 7 of the Revised Penal Code. Q. On February 24, 2006, President Gloria Macapagal Arroyo issued Proclamation number 1017, declaring a state of national emergency. Is this proclamation constitutional? Explain. The proclamation is constitutional insofar as it constitutes a call by the President for the AFP to prevent or suppress lawless violence, as this is sustained by Section 18, Article 7 of the Constitution. However, PP, Presidential Proclamation 1017's provision giving the President express or implied power to issue decrees, Number 2, to direct the AFP to enforce obedience to all laws, even those not related to lawless violence, as well as decrees promulgated by the President. And 3, to impose standards on media or any form of prior restraint on the press are ultra vires and unconstitutional. Likewise, under Section 17, Article 12 of the Constitution, the President, in the absence of legislation, cannot take over privately owned public utilities and businesses affected with the public interest. David versus Arroyo, GR number 171396, May 3, 2006. Q. The President, concerned about persistent reports of widespread irregularities and shenanigans related to the alleged ghost projects with which the pork barrel funds of members of Congress had been associated, decided not to release the funds authorized under a Special Appropriation Act for the construction of a new bridge. The Chief Executive explained that to properly conserve and preserve the limited funds of the government, as well as to avoid further mistrust by the people, such a project, which he considered unnecessary since there was an old bridge near the proposed bridge, which was still functional, should be scrapped. Does the President have such authority? 2014 Bar. Answer. The President has the authority to withhold the release of the funds under a Special Appropriation Act for a project which he considered unnecessary. The faithful execution of the laws requires the President to desist from implementing a law if by doing so will prejudice public interest. It is folly to require the President to spend the entire amount appropriated in the law in such a case. Philippine Constitution Association versus Enriquez, 235 SCRA 506. Alternative answer. The President does not possess the authority to scrap the Special Appropriations Act for the construction of a new bridge. His refusal to spend the funds appropriated for the purpose is unlawful. The President is expected to faithfully implement the purpose for which Congress appropriated funds. Generally, he cannot replace legislative discretion with his own personal judgment as to the wisdom of a law. Araulo versus Aquino, GR number 209287, July 1, 2014. Power of appointment. Q. When is an appointment in the civil service permanent? Distinguish between an appointment in an acting capacity, extended by a department secretary, from an ad interim appointment, extended by the President. Distinguish between a provisional and a temporary appointment. Answer. Number 1. Under Section 25A of the Civil Service Decree, an appointment in the civil service is permanent when issued to a person who meets all the requirements for the position to which he is being appointed, including the appropriate eligibility prescribed in accordance with the provisions of law, rules, and standards promulgated in pursuance thereof. Number 2. An appointment in an acting capacity extended by a department secretary is not permanent but temporary. Hence, the department secretary may terminate the services of the appointee at any time. On the other hand, an ad interim appointment extended by the President is an appointment which is subject to confirmation by the Commission on Appointments and was made during the recess of Congress, as held in Summers versus Quezada, 81 Phil 754, as an ad interim appointment is permanent. 3. In Section 24D of the Civil Service Act of 1959, a temporary appointment is one issued to a person to a position needed only for a limited period, not exceeding 6 months. Under Section 25B of the Civil Service Decree, a temporary appointment is one issued to a person who meets all the requirements for the position to which he is being appointed, except the appropriate civil service eligibility because of the absence of appropriate eligibles, and it is necessary in the public interest to fill the vacancy. On the other hand, Section 24E of the Civil Service Act of 1959 defined a provisional appointment as one issued upon the prior authorization of the Civil Service Commission in accordance with its provisions and the rules and standards promulgated in pursuance thereto, to a person who has not qualified in an appropriate examination but who otherwise meets the requirements for appointment to a regular position in the competitive service, whenever a vacancy occurs and the filing thereof is necessary in the interest of the service and there is no appropriate register of eligibles at the time of appointment. Provisional appointments in general have already been abolished by Republic Act 6040. However, it still applies with regard to teachers under the Magna Carta of Public School Teachers. Q. What is the nature of an acting appointment to a government office? Does such an appointment give the appointee the right to claim that the appointment will in time ripen into a permanent one? Explain. Answer. According to Sevilla v. Court of Appeals 2009-637, an acting appointment is merely temporary, as held in Marhomsar v. Alonto 194-390. A temporary appointment cannot become a permanent appointment unless a new appointment, which is permanent, is made. This holds true unless the acting appointment was made because of a temporary vacancy. In such a case, the temporary appointee holds office until the assumption of office by the permanent appointee. Question. In March 2001, while Congress was adjourned, the President appointed Santos as chairman of the Commission on Elections. Santos immediately took his oath and assumed office. While his appointment was promptly submitted to the Commission on Appointments for confirmation, it was not acted upon, and Congress again adjourned. In June 2001, the President extended a second ad interim appointment to Santos for the same position with the same term, and this appointment was again submitted to the Commission on Appointments for confirmation. Santos took his oath anew and performed the functions of his office. Reyes, a political rival, filed a suit assailing certain orders issued by Santos. He also questioned the validity of Santos' appointment, resolved the following issues. A. Does Santos' assumption of office on the basis of the ad interim appointments issued by the President amount to a temporary appointment which is prohibited by Section 1, 2, Article 9C of the Constitution? Answer. The assumption of office by Santos on the basis of the ad interim appointment issued by the President does not amount to a temporary appointment. An ad interim appointment is a permanent appointment because it takes effect immediately and can no longer be withdrawn by the President once the appointee has qualified into office. Assuming the legality of the first ad interim appointment and assumption of office by Santos, where his second ad interim appointment and subsequent assumption of office to the same position, violations of the prohibition on reappointment under Section 1 to Article 9C of the Constitution? The second ad interim appointment of Santos does not violate the prohibition against reappointment under Section 1, Number 2, Article 9C of the Constitution. The prohibition does not apply to a bypassed ad interim appointment because it has not been finally disapproved by the Commission on Appointments. The prohibition against a reappointment in the Constitution presupposes the end of the term. After the end of the term, he cannot be reappointed. Q. While Congress was in session, the President appointed 8 acting secretaries. A group of senators from the minority bloc questioned the validity of the appointments in a petition before the Supreme Court on the ground that while Congress is in session, no appointment that requires confirmation by the Commission on Appointments can be made without the latter's consent, and that an undersecretary should instead be designated as acting secretary should the petition be granted. 2013 Bar. Answer. No. The petition should not be granted. The department head is an alter ego of the President and must enjoy his confidence even if the appointment will be merely temporary. The senators cannot require the President to designate an undersecretary to be the temporary alter ego of the President. That is under Pimentel v. Ermita 472 SCRA 587. Q. A was a career ambassador when he accepted an ad interim appointment as cabinet member. The Commission on Appointment bypassed his ad interim appointment, however, and he was not reappointed. Can he reassume his position as career ambassador? 2010 bar. Answer: the career ambassador cannot reassume his position as career ambassador. His ad interim appointment as cabinet member was a permanent appointment. Summers versus Ozaita, 81 Phil 754. He abandoned his position as ambassador when he accepted his appointment as cabinet member because as cabinet member he could not hold any other office during his tenure. Section 13, Article 7 of the Constitution. Q. The President appointed Dexter 1 T as chairman of the COMELEC on June 14, 2011 for a term of 7 years pursuant to the 1987 Constitution. His term of office started on June 2, 2011 to end on June 2, 2018. Subsequently, the President appointed Ms. Marikit as the third member of the COMELEC for a term of 7 years starting June 2, 2014 until June 2, 2021. On June 2, 2015, Chairperson T retired optionally after having served the government for 30 years. The President then appointed Commissioner Marikit as COMELEC chairperson. The Commission on Appointments confirmed her appointment. The appointment papers expressly indicate that Marikit will serve as COMELEC chairperson until the expiration of the original term of her office as COMELEC Commissioner on June 2, 2021. Matalino, a taxpayer, files a petition for certiorari before the Supreme Court asserting that the appointment of Marikit as COMELEC chairperson is unconstitutional for the following reasons. Number 1. The appointment of Marikit as COMELEC chairperson constituted a reappointment which is prescribed by Section 1, Number 2, Article 9 of the 1987 Constitution, and Number 2, the term of office expressly stated in the appointment papers of Marikit likewise contravenes the aforementioned constitutional provision. Will the constitutional challenge succeed? Explain, 2015 bar. Answer: the first argument is untenable since Commissioner Marikit was not reappointed but actually was a promotional appointment as she had not yet fully served her term. What the Constitution prohibits is a reappointment of a COMELEC commissioner after serving the 7-year term. On the second argument, the limitation of the term of Commissioner Marikit as chairman until expiration of her original term on June 2, 2021 is valid only until June 8, 2018. That is, the unexpired portion of the last chairman's term, but invalid if until 2021 as it exceeds the limitation. A promotional appointment is allowed provided that the aggregate period of the term of the appointee will not exceed 7 years and that the rotational scheme of staggering terms of the commission membership is maintained. Funa versus Ermita, 2012. Q. While Congress was in session, the President appointed Antero as Secretary of the Department of Tourism, Benito as Commissioner of the Bureau of Immigration, Clodoaldo as Chairman of the Civil Service Commission, Dexter as Chairman of the Commission on Human Rights, and Emmanuel as Philippine Ambassador to Cameroon. The following day, all the appointees took their oath before the President and commenced to perform the functions of their respective offices. A. Characterize the appointments, whether permanent or temporary, and whether regular or interim, with reasons. Letter B. A civil society group, the Volunteers Against Misguided Politics, VAMP, filed suit contesting the legality of the acts of the appointees and claiming that the appointees should not have entered into the performance of the functions of their respective offices because their appointments had not yet been confirmed by the Commission on Appointments. Is this claim of VAMP correct? Why or why not? Answer to letter A. The appointment of Antero as Secretary of Tourism is ad interim because it is subject to confirmation of the Commission on Appointments and was made while Congress was not in session. He can start performing his duties upon his acceptance because it is permanent and cannot be withdrawn after its acceptance. Matibag versus Benipayo, 380 Squa 49, 2002. Number 1. The appointment of Benito as Commissioner of the Bureau of Immigration is regular and permanent. It is not required to be confirmed by the Commission on Appointments. He can start performing his duties upon acceptance of the appointment. The appointment of Clodoaldo as chairman of the Civil Service Commission is an ad interim because it is subject to confirmation by the Commission on Appointments and was made while Congress was not in session. He can start performing his duties upon his acceptance of the appointment because it is permanent and cannot be withdrawn. The appointment of Dexter as chairman of the Commission on Human Rights is regular and permanent upon his acceptance. It is not required to be confirmed by the Commission on Appointments. He can start performing his duties upon his acceptance. The appointment of Emmanuel as ambassador to Cameroon is an ad interim because it is subject to confirmation by the Commission on Appointment. B. The claim of VAMP is not correct. The Commission of Investigation and the Commission on Human Rights can immediately start performing their due functions upon acceptance since they are not required to be confirmed. The Secretary of the Department of Tourism and the Chairman of the Civil Service Commission can immediately start performing their duties upon acceptance since their ad interim appointment is permanent. Commission on Appointments Confirmation. Q. What are the 6 categories of officials who are subject to the appointing power of the President? Number 2. Name the category or categories of officials whose appointments need confirmation by the Commission of Appointments. Answer. Under Section 16, Article 7 of the Constitution, the 6 categories of officials who are subject to the appointing power of the President are the following. Head of Executive Departments. B. Ambassadors, other public ministers, and consuls. C. Officers of the Armed Forces from rank of colonel or naval captain. D. Other officers whose appointments are vested in him by the Constitution. E. All other officers of the government whose appointments are not otherwise provided by law. N. F. Those who may be authorized by law to appoint. Number 2. According to Sarmiento versus Mison, 156 549, the only officers whose appointments need confirmation by the Commission on Appointments are the head of executive departments, ambassadors, other public ministers, and consuls, officers of the armed forces from the rank of colonel or naval captain, and other officials whose appointments are vested in the President by the Constitution. Q. In December 1988, while Congress was in recess, A was extended an interim appointment as Brigadier General of the Philippine Army. In February 1989, when Congress was in session, B was nominated as Brigadier General to the Philippine Army. B's nomination was confirmed on August 5, 1989, while A's appointment was confirmed on September 5, 1989. Who is deemed more senior of the two, A or B? Suppose Congress adjourned without the Commission on Appointments. Acting on both appointments, can A and B return the original ranks of colonel? Answer. A is senior to B, in accordance with the ruling in Summers versus Oseta, 81 Field 754. The ad interim appointment extended to A is permanent and is effective upon his acceptance, although it is subject to confirmation by the Commission on Appointments. If Congress adjourned without the appointments of A and B having been confirmed by the Commission on Appointments, A cannot return to his old position, as held in Summers versus Osaeta, 81 Field 754, by accepting an ad interim appointment to a new position. A waived his right to hold his old position. On the other hand, since B did not assume the new position, he retained his old position. Q. On December 13, 1990, the President signed into law Republic Act No. 6975, subsequently amended by RA No. 8551, creating the Department of Interior and Local Government, Section 26 and 31 of the law provide that senior officers of the Philippine National Police or PNP, from Senior Superintendent, Chief Superintendent, Deputy Director General to Director General or Chief of PNP, shall among others be appointed by the President, subject to confirmation by the Commission on Appointments. In 1991, the President promoted Chief Superintendent Roberto Matapang and Senior Superintendent Conrado Mahigpit to the position of Director and Chief Superintendent of the PNP, respectively. Their appointments were in a permanent capacity, without undergoing confirmation by the Commission on Appointments. Matapang and Mahigpit took their oath of office and assumed their respective positions. Thereafter, the Department of Budget and Management authorized disbursement for their salaries and other emoluments. Juan Bantay filed a taxpayer suit questioning the legality of the appointments and disbursement made. Bantay argues that the appointments are invalid inasmuch as the same have not been confirmed by the Commission on Appointments as required under Section 26 and 31 of the RA 6975. Determine with reasons the legality of the appointments and the disbursements for salaries by discussing the constitutional validity of Section 26 and 31 of RA number 6975. Answer. The appointments of Matapang and Mahigpit are valid even if they were not confirmed by the Commission on Appointments because they are not among the public officials whose appointments are required to be confirmed by the first sentence of Article 7, Section 16 of the Constitution. According to Manalo versus Sistoza 312 Squat 239, Section 26 and 31 of the Republic Act 6975 are unconstitutional because Congress cannot by law expand the list of public officials required to be confirmed by the Commission on Appointments. Since the appointments of Matapang and Mahigpit are valid, the disbursements of their salaries and emoluments are valid. Doctrine of Qualified Political Agency. Q. A law provides that the secretaries of the Department of Finance and Trade and Industry, the Governor of the Central Bank, the Director General of the National Economic Development Authority, and the Chairperson of the Philippine Overseas Construction Board shall sit as ex officio members of the Board of Directors of a government-owned and controlled corporation, GOCC. The other 4 members shall come from the private sector. The BOD issues a resolution to implement a new organizational structure, staffing pattern, position classification system, and a new set of qualification standards. After the implementation of the resolution, Attorney Di Pasupil questioned the legality of the resolution, alleging that the BOD has no authority to do so. The BOD claims otherwise, arguing that the doctrine of qualified political agency applies to the case. It contends that since its agency is attached to the Department of Finance, whose head, the Secretary of Finance, is an alter ego of the President, the BOD's acts were also the acts of the President. Is the invocation of the doctrine of the BOD proper? Explained, 2015 bar. The invocation of the Board of Directors of the doctrine of qualified political agency is not proper. The doctrine of qualified political agency essentially postulates that the head of the various executive departments are the alter egos of the President, and thus the actions taken by such heads in the performance of their official duties are deemed the acts of the President unless the President himself should disapprove such acts. This doctrine is in recognition of the fact that in our presidential form of government, all executive organizations are adjuncts of a single chief executive, that the heads of the executive departments are assistants and agents of the chief executive, and that the multiple executive functions of the President as the chief executive are performed through the executive department. The doctrine has been adopted here out of practical necessity, considering that the President cannot be expected to personally perform the multifarious functions of the executive office. The cabinet members sat on the Board of Directors ex officio, or by reason of their office or function, not because of their direct appointment to the board by the President. Evidently, it was the law, not the President, that set them in the board. Under the circumstances when the members of the board of directors effected the, the assailed reorganization, that were acting as the responsible members of the board of directors constituted pursuant to the law, not as the alter egos of the President. Military powers. Q. Declaring a rebellion. Hostile groups have opened and maintained armed conflicts on the island of Sulu and Basilan. A. To quell this, can the President place under martial law the islands of Sulu and Basilan? Give your reasons. B. What are the constitutional safeguards of the exercise of the President's power to proclaim martial law? Answer. If public safety requires it, the President can place Sulu and Basilan under martial law, since there is an actual rebellion. Under Section 18, Article 7 of the Constitution, the President can place any part of the Philippines under martial law in case of rebellion when public safety requires it. B. The following are the constitutional safeguards of the exercise of the power of the President to proclaim martial law. A. There must be an actual invasion or rebellion. B. The duration of the proclamation shall not exceed 60 days. C. Within 48 hours, the President shall report his action to Congress. If Congress is not in session, it must convene within 24 hours. D. Congress may by majority vote of all its members, voting jointly, revoke the proclamation, and the President cannot set aside the revocation. E. By the same vote and in the same manner, upon initiative of the President, Congress may extend the proclamation if the invasion or rebellion continues and public safety requires the extension. F. The Supreme Court may review the factual sufficiency of the proclamation, and the Supreme Court must decide the case within 30 days from the time it was filed. G. Martial law does not automatically suspend the privilege of the writ of habeas corpus or the operation of the Constitution. H. It does not supplant the functioning of the civil courts and of Congress. Military courts have no jurisdiction over civilians where civil courts are able to function. Q. What do you mean by the calling out power of the President under Section 18, Article 7 of the Constitution? Answer. The calling out power of the President refers to the power of the President to order the armed forces whenever it becomes necessary to suppress lawless violence, invasion, or rebellion. Q. The President issued a proclamation number 1018 placing the Philippines under martial law on the ground that a rebellion staged by lawless elements is endangering the public safety. Pursuant to the proclamation, suspected rebels were arrested and detained, and military tribunals were set up to try them. Robert de la Cruz, a citizen, filed with the Supreme Court a petition questioning the validity of Proclamation number 1018. Does Robert have a standing to challenge Proclamation number 1018? Explain. In the same suit, the Solicitor General contends that under the Constitution, the President, as the Commander-in-Chief, determines whether the exigency has arisen requiring the exercise of a power to declare martial law, and that his determination is conclusive upon the courts. How should the Supreme Court rule? The Solicitor General argues, in any event, the determination of whether the rebellion poses danger to public safety involves a question of fact, and the Supreme Court is not a trier of facts. What should be the ruling of the court? And finally, the Solicitor General maintains that the President reported to Congress such proclamation of martial law, but Congress did not revoke the proclamation. What is the effect of the inaction of the Congress on the suit brought by Robert to the Supreme Court? Answer to letter A. Robert has standing under Article 8, Section 17 of the 1987 Constitution. The Supreme Court may review, in an appropriate proceeding filed by any citizen, the sufficiency of the factual basis of the proclamation of the martial law. A citizen, therefore, Robert may file the petition questioning Proclamation 1018. Answer to B. The Supreme Court should rule that his determination is not conclusive upon the courts. The 1987 Constitution allows a citizen, in an appropriate proceeding, to file a petition questioning the sufficiency of the factual basis of the said proclamation. Moreover, the power to suspend the privilege of the writ of habeas corpus and the power to impose martial law involve the curtailment and suppression of certain basic civil rights and individual freedoms, and thus necessitate safeguard by Congress and review by the Supreme Court. Answer to C. Judicial power include the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. When the grant of power is qualified, conditional, or subject to limitations, the issue of whether the prescribed qualifications or conditions have been met or the limitations respected is justiciable. The problem being one of legality or validity, not its wisdom. Article 7, Section 18 of the 1987 Constitution specifically grants the Supreme Court the power to review, in an appropriate proceeding filed by any citizen, the sufficiency of the factual basis of the proclamation. Thus, in the matter of such declaration, two conditions must concur. 1. There must be an actual invasion or rebellion, and 2. Public safety must require it. The Supreme Court cannot renege on its constitutional duty to determine whether or not the said factual conditions exist. D. The inaction of Congress has no effect on the suit brought by Robert to the Supreme Court, as Article 8, Section 18 provides for checks on the President's power to declare martial law to be exercised separately by Congress and the Supreme Court. Under said provision, the duration of martial law shall not exceed 60 days, but Congress has the power to revoke the proclamation or extend the period. On the other hand, the Supreme Court has the power to review the said proclamation and promulgate its decision thereon within 30 days from its filing. Q. Distinguish the President's authority to declare a state of rebellion from the authority to proclaim a state of national emergency. Answer. The power of the President to declare a state of rebellion is based on the power of the President as Chief Executive and Commander-in-Chief of the Armed Forces of the Philippines to suppress it. It is not necessary for the President to declare a state of rebellion before calling out the Armed Forces of the Philippines to suppress it. The proclamation only gives notice to the nation that such a state exists and that the Armed Forces of the Philippines may be called upon to suppress it. On the other hand, a proclamation of a state of national emergency, the President is already calling out the armed forces of the Philippines to suppress not only rebellion but also lawless violence. Q. Typhoon Bangis devastated the province of Sinagtala. Roads and bridges were destroyed, which impeded the entry of vehicles into the area. These caused food shortage, resulting in massive looting of grocery stores and malls. There is power outage also in the area. For these reasons, the governor of the province declares a state of emergency in their province through proclamation number 1. He also invokes Section 465 of the Local Government Code of 1991, RA 7160, which vests on the provincial governor the power to carry out emergency measures during man-made and natural disasters and calamities, and to call upon the appropriate national law enforcement agencies to suppress disorder and lawless violence. In the same proclamation, the governor called upon the members of the Philippine National Police, with the assistance of the Armed Forces of the Philippines, to set up checkpoints and choke points, conduct general searches and seizures, including arrest and other actions necessary to ensure public safety. Was the action of the provincial governor proper? Explain. 2015 bar. Answer. No, the provincial governor is not endowed with the power to call upon the armed forces at his own bidding. In issuing the assailed proclamation, Governor Tan exceeded his authority when he declared a state of emergency and called upon the armed forces and the police. The calling out powers contemplated under the Constitution is exclusive to the President, and exercised by another official, even if he is the local chief executive, is ultra vires and may not be justified by the invocation of Section 465 of the Local Government Code, since said provision only refers to calamities and disasters only and not of looting, as in the instant case. Culayan versus Tan, July 3, 2012. Pardoning powers. Q. A. While serving imprisonment for estafa, upon recommendation of the Board of Pardons and Parole, was granted pardon by the President on condition that he should not again violate any penal law of the land. Later, the Board of Pardons and Parole recommended to the President the cancellation of the pardon granted him because A. had been charged with estafa on 20 counts and was convicted of the offense charged, although he took an appeal therefrom which was still pending. As recommended, the President canceled the pardon he had granted to A. A was thus arrested and imprisoned to serve the balance of his sentence in the first case. A claimed in his petition for habeas corpus filed in court that his detention was illegal because he had not yet been convicted by final judgment and was not given a chance to be heard before he was recommitted to prison. Is A's argument valid? Answer. The argument of A is not valid, as held in Torres v. Gonzalez. A judicial pronouncement that a convict who was granted a pardon subject to the condition that he should not again violate any penal law is not necessary before he can be declared to have violated the condition of his pardon. Moreover, a hearing is not necessary before A can be committed to prison. By accepting the conditional pardon, A agreed the determination by the President that he violated the condition of his pardon shall be conclusive upon him, and an order for his arrest should at once issue. Q. Governor A was charged administratively with oppression and was placed under preventive suspension from office during the pendency of his case. Found guilty of the charge, the President suspended him from office for 90 days. Later, the President granted him clemency by reducing the period of his suspension to the period he has already served. The vice governors questioned the validity of the exercise of executive clemency on the ground that it could be granted only in criminal, not administrative cases. How should the question be resolved? Answer. The argument of the vice governor should be rejected, as held in Lamas v. Orbos. The power of executive clemency extends to administrative cases. In granting the power of executive clemency upon the President, Section 19, Article 7 of the Constitution does not distinguish between criminal and administrative cases. Section 19, Article 7 of the Constitution excludes impeachment cases, which are not criminal cases, from the scope of the power of executive clemency. If this power may be exercised only in criminal cases, it would have been unnecessary to exclude impeachment cases from this scope. If the President can grant pardons in criminal cases, with more reason he can grant executive clemency in administrative cases, which are less serious. Q. What are the constitutional limitations on the pardoning power of the President? 1999-2015 Bar. Distinguish between pardon and amnesty. Answer. The following are the limitations on the pardoning power of the President. A. It cannot be granted in case of impeachment. B. Reprieves, commutations, pardon, and remission of fines and forfeitures can be granted only after conviction by final judgment. C. Amnesty requires the concurrence of the majority of all members of Congress. D. The favorable recommendation of the Comelec is required for violation of election laws, rules, and regulations. Letter E. The President cannot pardon members and the employees of the judiciary found guilty by the Supreme Court in administrative cases. Number 2. According to Barry Quinto versus Fernandez 82 Phil 642, the following are the distinctions between pardon and amnesty. A. Pardon is a private act and must be pleaded and proved by the person pardoned, while amnesty is a public act of which courts take judicial notice. B. Pardon does not require the concurrence of the Congress, while amnesty requires the concurrence of Congress. C. Pardon is granted to individuals, while amnesty is granted to classes of persons or communities. D. Pardon may be granted for any offense, while amnesty is granted for political offenses. E. Pardon is granted after final conviction, while amnesty may be granted at any time. And F. Pardon looks forward and relieves the offender from the consequences of his offense, while amnesty looks backward and the person granted it stands before the law as though he had committed no offense.